right, let's go on the record. State's attorneys present, defendant and defense counsel are present. I have passed out, I didn't email, but I did give you guys both a copy of the court's proposed charge. I did not, after much research last night and reading the brief that Mr. Gertz sent also last night late, decide that there would not be a manslaughter instruction. Apparently, Mr. Coleman came in and agreed with that. I'm not sure what time he decided that. Would have been good to know before I was up most of the night. So,
just found out this morning.
Okay.
My appellate person, her opinion.
Okay. So it is now in the form really that we worked on for some number of hours yesterday afternoon. And the only thing that I think that there was something that needed to be on the record, and I'll let you guys do whatever, but I know, Mr. Gertz, you wanted to put something on the record with regard to the law parties.
Yes, Judge, or really accomplice witness testimony.
That's what I meant, I'm sorry.
We had a long discussion off the record yesterday. I want the record to reflect now. We printed out copies of potential instructions for accomplice as a matter of law, accomplice as a matter of fact. And after much consideration by me and our team, we made the strategic decision not to include that, in part because we believe it unduly complicates the charge. And also, there are some cases where it's obvious that the person is an accomplice, or it's obvious that a crime occurred, or that this crime occurred. This feels like a case where our primary argument to the jury is going to be that Mr. Batiste, that nobody even proved Mr. Batiste was actually involved, but even if they did, that he didn't know that the substance that was being delivered was fentanyl. And I feel like some of the language in there treats it almost as if it's a foregone conclusion that a crime occurred and that this crime occurred. And so we elected specifically not to include that instruction, and that was a strategic decision that our team agreed on.
All right, thank you. Mr. Gertz, are there any other requested additions, corrections, objections? I know y'all haven't had the time to look at the very last form, but it did make those adjustments that we discussed yesterday. I'll give y'all a few minutes to go over that. The only other thing I want to go over at this point, Mr. Coleman,
yes,
really this has more to do probably with you than Mr. Gertz. I did not include the requested yesterday. We had a definition or something that was out of the pattern jury charge that had to do with the fact that knowingly deliver meant that he knew it was a controlled substance. Mr. Gertz said if we're going to have it, it should say fentanyl. We all kind of agreed if it's not going to say fentanyl to take it out. Just like I would tell the defense in any case with regard to jury nullification. I know there is disagreement on what you and your staff, I think, believe the gist of the law is and whether or not the defendant needs to have knowledge of fentanyl. And yesterday I skirted the issue somewhat of saying that I don't know that that's my position. It's exactly my position. That is what my job is to make sure that the jury knows what I believe, at least my reading of the law. And so my reading of this law is, I think, very clear. I've reached out to several other judges also who have tried these cases, who have the same opinion, is that the defendant, really, in my opinion, the plain reading of 1902b4 is that he not just know that he delivers, there's no comma, there's no but, there's no anything else, knows that he manufactures or delivers a drug in penalty group 1B, which is fentanyl. And so what I am not going to allow is you to stand up and say the law is he did not have to know, because I don't believe that that is the law. So I want to make sure before you get started that you can do what you need to do to try to explain to them he should have known, whatever you want to say. It just cannot be the law is this. If I allow y'all to both get up there and do that, the first question from the jury is going to be, did he have to know? And that's a legal question, and so I want to make sure that that shouldn't be a legal question once we get started on that. Another reason, just because some of the research I did, because I did so much of it. If you take out the word deliver and you just use manufacture, let's just assume it was a manufacturing. I think it's common sense that he would be manufacturing fentanyl, not manufacturing some other drug, because it would be the manufacturer that put the fentanyl in, whatever it was. So you can't say, take manufacture and use it one way, and take deliver and use it a different way. That's just part of the English major grammatical reading of that sentence that, in addition to about, I think, 14 cases that I went through last evening. So with that being said, I'll give y'all a minute to go through. If there is any last minute, anything that you guys see in the charge, I'll take care of it when I come back in. All right?
All right.
The real Tommy Coleman has shown up.
Yeah, old habits die hard, man. That's the final draft without the, answer.
Can you check it out, or can she?
She already decided to take it out.
Didn't put the definition of constructed.
It's in there somewhere, I remember seeing it. It's in there.
Y'all thinking of doing that?
Sneak it in there. I'm sneaking my fingers. All right.
Y'all finish? Thanks, y'all can be seated. Actually, I'm here. I don't think I was muted all that time. I don't need this. Okay, let the record reflect again, state's attorney's present, defendant, defense counsel are present. Any other issues, argument, objections, requested additions, corrections to the charge?
Not from the state judge.
I'm sorry, no, Judge. No.
All right, how long would either of you request for closing-ish?
15 minutes, Judge.
Okay, all right.
I'll be some compromise.
I'll let you go I'll let you know if you seem to be going a little too long.
Thank you, Judge.
Also, did we get, I just want to make sure, all the evidence, did y'all get that, the pictures adjusted and all of that? I'm sorry?
I'll get it today, I promise.
Okay, so they need to get it done pretty quick this morning so that if there is a request for those, it'll be easier to send that in. So if they can start working on that, it's just those pictures for those two. We'll need that down here pretty quick. All right, anything else? And what we're talking about, he's going to take the two ID techs photos that were on the thumb drives and have them printed out instead of on a thumb drive. It's easier for, I think, the jury if they wanted to see it, as well as for the court reporter. So that he has those two exhibits
Okay.
and is going to get those, and we'll make that substitution as soon as that's done. All right, then you can bring the jury in. Good morning. Let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. So at this time, ladies and gentlemen, I am required to read the entire court's charge to you. So here we go. Cause numbers 24 DCCR 0917 and 24 DCCR 0918, the state of Texas versus Dalton Batiste. Jury instructions. Members of the jury, the defendant, Dalton Batiste, stands charged by indictment in each case with the offense of murder. The defendant has pleaded not guilty, and you have heard all the evidence in each case. The parties will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether or not the state has proved the defendant guilty in each case. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable in this case. General principles. The indictments are not evidence of guilt. the indictments or documents required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, indicted, or otherwise charged. Do not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charges. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. You may find the defendant guilty only after a careful and impartial consideration of all of the evidence, and only if the state has proved the defendant's guilt beyond a reasonable doubt. The state has the burden to prove every element of the offense beyond a reasonable doubt. If the state proves every element of the offense beyond a reasonable doubt in each case, then you must find the defendant guilty in each case. If it does not, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty in either case, you must find the defendant not guilty in that case. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in the cases should be considered by you as my opinion about the facts of the cases or influence you to vote one way or the other in either case. You should give terms their common meanings, unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the cases under the law that is in these instructions. Do not allow your verdicts to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in dispute. The law requires that you render a verdict of either guilty or not guilty in each case. The verdict of not guilty simply means that the state has not proved the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict in each case. When you reach a verdict in each case, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand, or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. During the trial, you heard evidence that the defendant may have committed wrongful acts not charged in the indictment. The state offered the evidence to show absence of mistake and knowledge. You are not to consider that evidence at all unless you find beyond a reasonable doubt that the defendant did, in fact, commit the wrongful act. Those of you who believe the defendant did the wrongful act may consider it. Even if you do find that the defendant committed a wrongful act, you may consider this evidence only for the limited purpose I have described. You may not consider this evidence to prove that the defendant is a bad person and for this reason was likely to commit the charged offense. In other words, you should consider this evidence only for the specific, limited purpose I have described. To consider this evidence for any other purpose would be improper. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing argument by the attorneys, you will go into the jury room. Your first task will be to select your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet in each case. While deliberating and until excused by the trial court, all jurors must follow these rules. 1. You must not discuss the cases with any court officer or the attorneys or anyone not on the jury. 2. You must not discuss the cases unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the cases until all of you are present again. 3. You must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. 4. You must not conduct any independent investigations, research, or experiments. 5. You must tell the judge if anyone attempts to contact you about the cases before you reach your verdict. Your sole duty at this point is to determine whether the state has proved the defendant guilty in each case. You must restrict your deliberations to this matter. After you have arrived at your verdict in each case, you are to use the forms attached to these instructions. The foreperson should sign the line that corresponds to your verdict in each case. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict in each case. Relevant statutes that apply in both cases. Section 19.02b4 Texas Penal Code. A person commits the offense of murder if he knowingly manufactures or delivers a controlled substance included in penalty group 1B under section 481.1022 Health and Safety Code in violation of section 481.1123 Health and Safety Code, and an individual dies as a result of ingesting, inhaling, or introducing into the individual's body any amount of the controlled substance manufactured or delivered by the actor, regardless of whether the controlled substance was used by itself or with another substance, including a drug, adulterant, or diluent. Section 481.1022 Health and Safety Code. Penalty Group 1B consists of the following opiates, including their isomers, esters, ethers, salts, and salts of isomers, esters, and ethers, and salts, if the existence of these isomers, esters, ethers, and salts is possible within a specific chemical designation. Fentanyl, alpha-methafentanyl, and any other derivative of fentanyl. Sorry, those words are apparently hard for me to say. Section 481.1123. A person commits an offense if the person knowingly manufactures, delivers, or possesses with intent to deliver a controlled substance listed in Penalty Group 1B. Delivery of a controlled substance. A person commits the offense of delivery of a controlled substance if the person knowingly delivers a controlled substance by actual transfer or constructive transfer. Fentanyl is a controlled substance. A person delivers a controlled substance to another by actual transfer if the person has possession and control over the controlled substance and manually conveys that possession and control of the controlled substance to the other or to an agent of the other person. A person constructively transfers a controlled substance to another if the person had either direct or indirect control of the transferred substance before delivery and knew that it would be delivered to a transferee. Definitions: knowingly. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. Adulterant or dilutant means any material that increases the bulk or quantity of a controlled substance, regardless of its effect on the chemical activity of the controlled substance. Deliver means to transfer actually or constructively to another, regardless of any agency relationship between the other person and any other individual. And so that all applies to both cases. Now you're going to have two different sections, one for each of the cases. The cause numbers are at the top, separating them so you'll be able to tell which one's which. The first, cause number 24 DCCR 0917, law specific to this case. The state accuses the defendant of having committed the offense of murder. Application of law to facts. You must determine whether the state has proved beyond a reasonable doubt three elements. The elements are that 1, the defendant, Dalton Batiste, in Jefferson County, Texas, on or about January 10th, 2024, delivered by actual or constructive transfer a controlled substance included in penalty group 1B, namely fentanyl, and 2, an individual, Aaron Sanchez, died as a result of ingesting, inhaling, or introducing into his body any amount of the fentanyl delivered by the defendant, and 3, the defendant did this knowingly. You must all agree on elements 1, 2, and 3 listed above. If you all agree the state has failed to prove beyond a reasonable doubt any of elements 1, 2, or 3 listed above, you must find the defendant not guilty. If you all agree the state has proved each of the three elements listed above, has proved beyond a reasonable doubt each of the three elements listed above, you must find the defendant guilty. And then that has my signature at the bottom, and then you have the verdict form for that case. Cause number 24, DCCR 0917. It's titled, the top part, verdict, not guilty. We, the jury, find the defendant, Dalton Batiste, not guilty, and there is a line for the signature and then a line for the printed name of the foreperson. And then below that, verdict, guilty. We, the jury, find the defendant, Dalton Batiste, guilty of murder as charged in the indictment. Again, signature line and a line for the printed name of the foreperson. Then you go to cause number 24, DCCR 0918. The state accuses the defendant of having committed the offense of murder. Application of law to the facts. You must determine whether the state has proved beyond a reasonable doubt three elements. The elements are that 1, the defendant, Dalton Batiste, in Jefferson County, Texas, on or about January 10th, 2024, delivered by actual or constructive transfer a controlled substance included in penalty group 1B, namely fentanyl, and 2, an individual, Matthew Christ, died as a result of ingesting, inhaling, or introducing into his body any amount of the fentanyl delivered by the defendant, and 3, the defendant did this knowingly. You must all agree on elements 1, 2, and 3 listed above. If you all agree the state has failed to prove beyond a reasonable doubt any of elements 1, 2, and 3 listed above, you must find the defendant not guilty. If you all agree the state has proved beyond a reasonable doubt each of the three elements listed above, you must find the defendant guilty. Again, that has my signature, and then you have the verdict form for that case, 24 DCCR 0918. The top, verdict, not guilty. We, the jury, find the defendant, Dalton Batiste, not guilty. Signature line and line for the printed name of the foreperson. And then below that, you have verdict, guilty. We, the jury, find the defendant, Dalton Batiste, guilty of murder as charged in the indictment. Again, signature line and line for the printed name of the foreperson. All right, Mr. Coleman, the state has the right to open and close closing arguments.
Yeah, this time the state would waive its right to open, but reserve its right to close.
Thank you, Mr. Coleman. Mr. Gertz, you may proceed.
Yes, Judge, may I have a moment to get set up, please?
Yes, and with y'all's permission, I'm going to make the adjustment to those numbers that were messed up on page 8.
Thank you.
Thank you. No matter how many times we go over this, there's always something I find when I read it out loud.
Well, good morning, ladies and gentlemen. Thank you very much for your participation in this process, your willingness to listen to the evidence, the testimony, and consider this very important case. Before I talk with you about what we think the facts were and were not proven in this case, I'd like to talk to you a minute about your role as jurors. So I would suggest to you that you've actually won the citizenship lottery by actually making the jury and getting to be on the jury, because you're getting to participate in this amazing process that we have that lots of other places do not have. And jurors in this county make some of the most important decisions that you can make. Across the hall down there, they make decisions about taking money from one party and giving it to another. They make decisions in family court of who's going to get children in a custody dispute, or maybe get their children taken away from them by the state. And in the chairs that you're sitting in, I submit to you that jurors make the most important decisions that you can make as a jury, and that is about people's liberty and about their lives. And so I appreciate you. Dalton Batiste appreciates you. His family appreciates you, and you listening to this evidence in this case and these instructions, and hopefully following them and following the evidence in the case. And the judge told you one of her instructions is that your sole duty is to determine whether the state has proved the defendant guilty in each case. And I would submit to you that while that may feel like a collective task, it's actually an individual task that you have. And I talked to you in jury selection about each of you starting the case with an empty backpack. And this is where that comes home for you. Each of you individually needs to be satisfied that the government has filled up your individual backpack with believable, truthful, credible evidence. And if they have neglected to do so, if they have not satisfied you individually, your oath requires you to vote not guilty and to persist in that vote. And I would submit to you that if you find yourselves at an impasse, please, 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 if your backpack is not full, do not give way if you are not satisfied that they have proven each and every element of this case to you beyond a reasonable doubt. Now, the other thing you need to know about this process is that the buck stops with you. You can't come back next week and say, hey, Judge West, I actually had a doubt. I had a reasonable doubt. But I was persuaded, or I was forced, or I was told we can't go home until we, get this thing wrapped up. And so I gave up on it. You can't do that. Once your foreman signs that verdict form, that is the law of the case. Whatever you decide will decide the fate of Dalton Batiste, and it will decide whether or not the state has proven this case beyond a reasonable doubt. And I talked to you again in jury selection about sometimes the state will show you some evidence and say, this is really bad, this is really bad. But that your obligation is to ask hard questions and to force them to prove it to you beyond a reasonable doubt and to answer those questions to your satisfaction. And so let's look at the evidence in the case and let's see if they've done that. So the indictment reads, and this is very important, all the rest of it in the instructions the same, it'll read the exact same way, but the indictment really comes down to this question. Did Dalton Batiste knowingly manufacture or deliver a controlled substance included in penalty group 1B that caused the death of Matthew Price and Aaron Sanchez? And my partner, Mr. Kelly, told you that an indictment is a promise. An indictment is the state of Texas saying to you, I promise you, I will, at the end of this case, I will have proven this case to you. You will be satisfied. You will have no reasonable doubts when I get done. That's what they've promised you. And it all comes down to this issue here. And this will be in your instructions, but I've written it out for you. A person acts knowingly or with knowledge with respect to either the nature of their conduct or the circumstances surrounding their conduct when they are aware of the nature of their conduct or that the circumstances exist. So you can read this to me. A person acts knowingly with respect to delivering fentanyl when they are aware that they're delivering fentanyl, they're aware of the nature of their conduct, or they're aware that the circumstances of the fentanyl exist. That's what that means. It doesn't mean anything else. It doesn't mean somebody's aware that they sold some drugs. It doesn't mean they're aware that they had a controlled substance and they sold it to somebody and they don't really know about the fentanyl, whatever. No. This is what we're talking about. Did this person know he was selling fentanyl? Now, we'll get to whether or not he's even the person that did it. That's a separate problem. But this case comes down to that question. And really, it comes down to the question of whoever sold these substances, whatever they were, did that person know? And was that person Dalton Batiste? So here's the first problem we got. Mr. Coleman is going to do a great job of getting out this timeline of these phone calls. We have no idea what's said on these phone calls. The DEA expert had to admit that a bunch of the phone calls were probably just a call and it went to voicemail. So we have no idea what the contents of those calls are. What we do know in terms of content is this, that Matthew was looking for party drugs, stimulants. He was looking for shrooms. He was looking for mollies. He was not looking for Percocet to go sit home and be cool. They wanted to party. That's what the evidence was. There's talk about Percocet. There's talk about, other pills and stuff. This is what they were looking for. This is what he went to 370 Long to buy. That's what they were looking for. And the second thing is, no one testified that Dalton actually sold pills to Matthew or Elliot or anyone else on January 10th. There was no testimony about that. And there was no testimony about what Matthew actually purchased, nor from whom. We don't know who was at the top of the stairs, except that it was a black man. That's what we know. It was a black man at the top of the stairs. We don't know what they bought. We don't know what they paid. We don't know what they got. And here's the thing. They cordoned off the scene. You remember I spent a bunch of time with the detective and with Officer Cross talking about the scene. If it's really true what Elliot told the law enforcement people that they bought 10 pills, where are the pills? I mean, there's 3 guys take them, maybe 4. If they each take 1, that's 4. So there ought to be 6 pills wandering around somewhere. Nobody checked anybody's pockets and found pills. Maybe somebody wandered off with them. But we don't have them. They couldn't test anything, so we don't know. We would just be speculating to say what these pills actually were. Now, obviously, whatever they were contained fentanyl, because that's what these guys consumed. But we don't know if those are the pills that came from 370 Long or not. We just don't know. Because they didn't find them, and I'm not saying they did anything wrong, they just weren't there. But they didn't find them, so they couldn't test them, so we don't know. And if we don't know, you don't know. And then here's the other thing. Detective Neal found no evidence of whether the person who sold the pills knew they contained fentanyl. Even if you assume for a minute that it's Dalton, where's the evidence that Dalton knew it was that the pills contained fentanyl? There is zero evidence. And no one testified, even though they did a week of surveillance on the 370 Long house. When was the time that Dalton ever set foot in that house, in that apartment? When was it? What day was that? There is no evidence connecting. His name's not on the lease. His name's not on the water bill. There's just no evidence connecting him to physical presence in that apartment. Those are reasons to doubt. Those are hard questions. If Mr. Coleman can answer those questions to your satisfaction, you can say, wow, you've overcome my reasonable doubts. And I would welcome him to do that. But it's not going to be for the evidence that came from this witness stand, and it's not going to be from anything over here. It just doesn't exist. Now here's the deal. How would a person, I asked Detective Neal, how would a person know if a pill contains fentanyl? How would they know? I said, probably the best person to know is the person who manufactured it, right? And he agreed. I said, because they will know what they put in it, what the ingredients are that they put in it, right? And he said, yes. And I said, and there are people out there that manufacture in mass quantities pills that look like one thing and are actually another thing and contain fentanyl, correct? And he said, yes. And I said, and the end user will not necessarily know that that's what they're taking. And that's what happened here. But here's the problem. In Detective Neal's jumping to conclusions, he skipped the fact that the end user won't know, but the immediate deliverer probably won't know either, unless they're the ones that manufactured them. So what do? If we're going to investigate this and we're going to blame somebody for murder, what do? Would you want to do, I asked him, you want to do a thorough investigation? You want to be detail-oriented? You want to run every lead, every question to ground? You can't jump to conclusions, you can't guess, you can't speculate. He agreed with all of that. So what did he do? On January 17th, Detective Neal and his team arrest Dalton after watching him do some hand-to-hand transactions. Okay? They don't actually have a search warrant for him at that point. They get his phone, and his phone's in evidence. I assure you that if there were texts with Dalton saying, man, I need some more of that fentanyl stuff, I need some more big this and big that, I need some killer stuff, Mr. Coleman would be in here flashing it all over the screen. We don't know. He got a search warrant for the phone. He told this family that it was so urgent that he needed to go through Matthew's phone that day because that first 12 hours is so important. And then he waited almost a month to look at Dalton's phone. In the meantime, he didn't get a search warrant for the 370 Long Road house. They could have executed that. I mean, this is serious. This is murder. This isn't a narcotics investigation. He didn't get a warrant for that. He didn't get a warrant for Dalton's house, the Plant Road house, which is where he actually lives. And his name's on the water bill. What could we have found? We don't have a pill press. We don't have pills. In fact, there's no evidence that Dalton has ever touched anything with fentanyl on it at all. Again, zero. In the car, after watching all these hand-to-hand transactions, they didn't pull over the people that were doing the transactions to see what happened, what they bought or was sold. They didn't do that. They just pulled Dalton over. And I asked him, you didn't find pills in the car? No, I didn't. You didn't find cocaine in the car? You didn't find methamphetamine in the car? You didn't find mushrooms in the car? No, we didn't. What did you find? A little bit of misdemeanor marijuana. On his worst day, that's what they got on Dalton. He's selling little bags of marijuana. That's the best you can conclude with the evidence that we have. Little pot dealer. Again, it's illegal in Texas, but it's legal in 37 other states. That's what they got on it. They got to fill up your backpack. They have to satisfy you with believable, truthful, credible evidence. They have to do so in a way that makes you 100% free of all reasonable doubt about whether he knew that he was delivering fentanyl to someone and those people died. If and when you have those doubts and you exercise them through hard questions, press to the state. We are going to ask you to vote not guilty. Thank you.
Thank you, Mr. Kurtz. Mr. Coleman?
Thank you, Your Honor. May it please the court, Mr. Gertz, ladies and gentlemen of the jury, I am going to revert back to my old school chart. I think you saw throughout this trial, and the joke in my office is that if I didn't hear the computer, it will go crazy and malfunction. So I'm going to, and let me just apologize for that technical stuff with the Burla vehicle data dump and the Cellbrite cell phone dump and the playing of the body-worn camera video. You know, I could have brought my teenage nephew in here and he probably could have had an AI avatar or everything you make a presentation. I'm just not wired that way, but I did the best I can. Speaking of that evidence, I've taken the time to summarize the evidence here. We'll talk about it in just a second. I don't want to neglect thanking you for your time, thanking you for your attention on behalf of the District Attorney's Office and the citizens of Jefferson County, most importantly on behalf of the victims in this case, Aaron Sanchez and Matthew Christ. The victims' families, they get overlooked sometimes when we get to this point, and the focus is on the defendant all of the time. And rightfully so, the focus should be on the rights of the accused, the defendant, but the focus should also be, I submit to you, on the victims as well. Let me start also by saying, I was thinking about this case and the issues in this case, and it reminded me of my dad. My dad was a mechanic, a lifelong mechanic, and tools were all over the place. In fact, back in the 80s, even before it was a thing, he had one of these big toolboxes, multi-drawer deal with the wheels on it. And as a little kid, I was fascinated by all manner of tools that he had in there, pliers and wrenches and screwdrivers and that kind of thing. I came to appreciate early on that tools fix problems. And fentanyl, ladies and gentlemen, is a problem in our community. Make no mistake about that. All you need to do is turn on the news, read a newspaper, look at social media. People are dying from fentanyl every day. It is a problem. And the legislature, like the tools that my dad had to fix problems, has given you a tool to fix this problem of fentanyl in our case. And I'm asking you that in using that tool, as it applies to the evidence in this case, to get us started down the road of fixing that problem with these drug dealers in our community selling this poison, peddling this poison to our fellow citizens. Now, this is the case for that. This is what the legislature designed that case for. And this is the time to use that tool. You are that jury. And I submit to you that if you look to your left, look to your right, you'll see a fellow juror that feels the same way. That it's not hyperbole when I say to you that your verdict very well could save lives in that it sends a message. Could send a message to a wannabe Dalton Batiste who's out there thinking about selling pills, and they'll think twice if they know that they face a murder charge. That's my pitch to you. It's not just a pitch. I'm asking you to do so based on the evidence. Now, you can draw reasonable inferences from the evidence. And despite what Mr. Gertz says, who is always a formidable advocate for his client in each and every case, despite what he says, don't take my word for it. Look in this jury charge when you get back there to deliberate. It says that you can draw inferences from the evidence in the case. Inferences means you can use your common sense to draw reasonable conclusions from the evidence in this case, okay? We're going to talk about the conclusions that you can draw from the evidence in this case in just a second. In fact, let's do it right now. We had all of the data from the Burley dump, 1,000 pages. We had the data from the cell phones, and I fumbled over and stumbled over trying to get them into evidence for you. So I thought I would just distill that evidence down as simply as I could. And I broke it down into four categories here for you. What we got here are the phone logs, the testimony of Howard Celestine, the text, and the vehicle data. You know what those four categories do? They line up when you put them side by side. That's what they do. And when they line up, like the pieces of the puzzle that we talked about during jury selection, I submit to you that it's enough pieces to get you to beyond a reasonable doubt. Just like we talked about, if you remember that puzzle that I showed, where some of the pieces were missing of the puppy, but yet still you can still make out that puppy. Mr. Gertz wants you to have 100% of all of those pieces in there, and it would be great if we had a surveillance video of this defendant committing the offense, but we don't. But I submit to you that between the phone logs, Howard Celestine's testimony, the text messages, and the vehicle data, that's enough pieces of the puzzle for you to infer, draw a reasonable conclusion that this defendant committed this offense, that this defendant had knowledge, that he knew that what he was selling and peddling contained fentanyl. And we'll talk about that right now. We'll circle back to this. Knowledge, knowing something, being aware of something. Here's another instance where you don't have to take my word for it. It is in this jury charge. Look at it when you get back there. The judge has given you the definition of knowing. It's knowing or acting knowingly with regard to whether or not there was fentanyl in the pills that this defendant sold. The definition says either you have actual awareness or you're aware that the circumstances may exist. Okay? I'll say it again because it's important. I think this case hinges on it. I think this case turns on that. Knowledge. The definition in this jury charge that this judge has given you says that knowingly means either you have actual knowledge that something exists or you're aware of the circumstances surrounding the situation. I'd like to take credit for this, but one of the attorneys walked into my office yesterday when I was working on this case, and they said, hey, drug dealers know their business. They know what they're selling. They know the product. And it got me to thinking, like any other business, a professional at that business, they know the business. I submit to you, you got evidence that this defendant has been trafficking in narcotics. I submit to you that that's his business. Like any other business, he knows his business. You can infer it. You can also use reasonable deductions that in knowing his business, he knew the circumstances surrounding the pills. A real estate agent knows what the interest rates are on houses. It's their business, okay? A teacher who teaches children, prepares them for the STAR test, know what the requirements are for the STAR test. I submit to you that you can infer, use your common sense to draw reasonable deductions based on the evidence that this defendant, Dr. Batiste, was a professional drug dealer, and you gotta know he knows his business. And even lay people who aren't in the business of selling drugs know by turning on the TV that the circumstances exist that there may be fentanyl in any field that you sell. I'll say it for one last time. Either you have actual knowledge that something is the way it is, or you are aware that the circumstances exist, that they may exist. That's all you need to get you there to where you need to be to find that this defendant had the requisite knowledge. Let's circle back to these evidence, the pieces of the puzzle. Phone logs, 9:20. Matthew Christ is either texting or calling Howard Celestine. If you juxtapose that, put that next to the testimony of Howard Celestine. They were talking, communicating earlier that night about a barbecue. A little later on, Celestine is either texting or calling Batiste. This is after the call between Christ. Then after the Batiste-Celestine communication, then there is the Celestine-Matthew Christ communication, which lines up with the testimony of Howard Celestine. You see it right here, that there was a communication between the two about, hey, he wants some Molly, let me call somebody, okay? That lines up with the actual text. You remember the phone logs just show calls to and from. But these actual contents of the text show that Matt asked Howard Celestine, do you have a plug? Someone who could provide drugs, okay? Celestine's response is, let me see. This lines up with this early communication that's shown by the phone logs. Let's skip down a little bit more. During the interview with Howard Celestine with law enforcement, Celestine says after the Christ call, I called Batiste, and then Celestine also says he gave Matt the address there for the residence on Long Street. That lines up, okay, with the call logs. Now, skip down a little more. I think the most important time frame here is around 10:41. There's a communication between Christ and Howard Celestine, and during the interview, Howard Celestine tells law enforcement that he told Matt to call him when he gets there, okay? So both the call log and the testimony of this defendant's cousin, mind you, would support that at 10:41, and the vehicle data reporter also shows that at 10:41, he was at Long Road. He called Howard Celestine, just like Howard Celestine said he did. Howard Celestine also told law enforcement that he communicated with Batiste, who told him to tell Matt to pull around back. That is supported by these short series of calls on the call log from Celestine to Batiste, 10:42, Celestine to Christ, 10:43, then Celestine back to Batiste. I submit to you when Celestine calls Batiste that last time, it is Celestine telling Batiste that Matt has pulled around the back and he's describing the vehicle that Matt is in. This lines up. In fact, if you look at the text show that Celestine texted the 370 Long Road address to Matt. It shows that Matt says, all right, we're going, which means he's rolling at around this time when these texts are happening between this 10:10 and 10:40 time frame, presumably between 10:23 to about 10:41 here as the vehicle data shows, starting out at Tyler Street, rolling toward Long Road, and then making its way down Delaware, near Phelan and Dowling at 10:38, ultimately at 10:41 making its way to Long Road. the fact that these all line up lends credibility to the overall story, the overall puzzle. And part of that overall puzzle is the testimony of Howard Celestine. And Howard Celestine says, quote it, I want to make sure I get it right here. Howard Celestine says, when Detective Neal asked him, he says, let's see. So, when he's pressed by Detective Neal, he tells Detective Neal that Batiste, that when he called, Celestine called Batiste, he says, hey, the pills you brokered killed people. He says, Neal asked him, hey, when people need pills, they come to your cousin. Your cousin delivers them. Isn't that right? Howard Celestine says, basically. When pressed during that interview, Neal asked him, hey, last night you knew that your cousin was going to sell Matt or Elliot or whoever pills, right? And Celestine says, from the phone call I made, yes. How do you know that that's true and credible? Because everything else that Howard Celestine said lines up. His testimony or his interview with law enforcement lines up with the times in the phone log. It lines up with the actual text in the data, the actual written text communication, and it lines up with the vehicle data. That's how you know that what he said was true, that his cousin, Dr. Batiste, was selling pills. Professional drug dealer who knows the craft like any other professional, and he's aware of the circumstances that surround selling pills in this day and age. That's how you get there, ladies and gentlemen. That's how you get to justice. And I'm going to do something I don't normally ask for. I'm asking for justice for Howard Celestine. In addition to asking for justice for the victim's family, our community, I'm asking for justice for Howard Celestine. Howard Celestine took responsibility. He's sitting in TDCJ prison right now for his role in this offense. And is that justice to let this defendant walk out of this courtroom? Finding him not guilty, getting on the elevator with you, riding down and walking out of this courthouse and going right back to the business of selling poison to our citizens in our community. Is that justice? I think not. So I'm asking for justice for Howard Celestine. On this point, Mr. Gertz and I agree. Mr. Gertz said that this is the most important decision you could make. That's what he said. I wrote it down. He said, and on that, he and I agree. Because your verdict in this case will not only hold this defendant accountable, but it will send a message that in Jefferson County, you sell the poison, you sell fentanyl, and somebody dies, we'll charge you with murder. I'm asking based on the evidence in this case that you do just that. Okay? I'm asking that based on this evidence and the law, that you find this defendant guilty of murdering Aaron Sanchez, guilty of murdering Matthew Christ. Thank you.
Thank you, Mr. Coleman. All right, ladies and gentlemen, at this time you've heard all the evidence, the court's charge and closing argument by counsel. I'm going to give the charge to the bailiff. She will get you settled in the jury deliberation room where you will be able to begin your deliberations. And for the alternate, if you'll just wait right there, we'll give you your instructions. You can all go with the bailiff to the jury deliberation room, and we'll be in recess until you reach a verdict. Thank you.